Now let's just talk a little bit about how your answering questions or doing rebuttal follows pretty much the same format. So answering that question, as we discussed earlier, if the judge asks you about a single fact, it gives you an excuse to launch into what the full rule is and all the facts that would apply. But up front, you should still deal with their question about that one fact. Likewise, the judge may say, well, you just mentioned the case of, and name the case, and you didn't fully talk about it, so why don't you tell me more about that case and how it affects here? So when they've asked you to talk about a case, the way you talk about the case is the way it is presented in the pretrial packet. Facts and the rule or holding you can combine and blend into one thing. But you do give the facts, so you'll give the facts that you've decided with your team help your side the most, the way you describe that case. You'll talk about what that court held, because that is the rule. Their holding is the rule from the case. And you don't have to use the words, Your Honor, the holding is the rule from the case. The shorthand term for attorneys to understand that you're citing to the rule is to say, the bumper court held, and you say what the holding was, and that is the rule from the case. Then you say, here, or in this case, and you talk about the facts from your case that the rule needs to be applied to. You can give a short summary. Your Honor, that's coercion. Your Honor, that was involuntary under bumper. Your Honor, that was involuntary under the all facts and circumstances test of Schneckloff. So sometimes during your rebuttal, a judge will stop you and ask you about something that the prosecution just argued or the other side just argued, and say, well, counsel, can you talk to me about this case that you haven't addressed that opposing counsel mentioned? And they name the case. And I've seen pretrial attorneys say, well, Your Honor, that case is not applicable. What you really should be looking at is this other case over here. And the problem there is that the judge has expressed to you that they're interested in hearing why the case is not applicable. They want to hear from you because maybe they think that other attorney's point was pretty good, and they need you to address the question they've asked you. They're asking about the case they just mentioned. So you say, Your Honor, in that case, and you give the facts, and then you say, and the court held, and you say what the holding was, and then you distinguish the case from your situation. Well, Your Honor, that case shouldn't apply because that was a consent given by a third party, and here my client was the defendant herself. As you can imagine, all 12 of these cases did not involve a detective coming onto a cruise ship and going to someone's tiny cabin and asking to search a safe. So you can distinguish cases on the facts alone to say, well, Your Honor, that was very different than our case. It's a little more powerful to distinguish it on the law that, well, Your Honor, that case was about custody. But the question here under Schneckloff is whether the person who was not in custody gave a voluntary consent, and the Schneckloff test would apply instead of this other test from Castaneda, which involved custody. So you can see there are multiple ways to distinguish cases and say that your argument is the proper one under binding case law, and the court should rule your way. A couple more things about how we talk during both questioning and our arguments and rebuttal. So the opposing counsel is a colleague of yours. Out in the real world, these people would see each other occasionally on a regular basis, and so they're colleagues and they're respectful of each other. Instead of saying opposing counsel is just wrong-headed and not understanding the issue, you'd say something like, opposing counsel has mentioned this case to apply, however, that is not the test that needs to be applied on the facts that are at issue. And we could say again, opposing counsel has mentioned a case on custody, but the test here as to just involuntariness when you're not in custody involves this other case, and the test is, and under that test, my client was involuntary. This brings up the next way to argue given the time limits in mock trial. You have 4 minutes and then 2 minutes, and the other side is arguing all of their side. And I know that when you talk with a parent or a teacher or out in the real world, it's a manner of speaking to soften the blow of disagreeing with someone by saying, well, your point that A, B, and C is well taken, and that's actually kind of a good point, but here, why don't you consider this other perspective? But you don't have time in mock trial to flesh out again what that opposing attorney's argument is, and you don't want to give it more voice and weight just by saying it again. So anything that you're going to disagree with the opposing counsel, for example, in rebuttal, is you've got 2 minutes and you've picked 3 to 5 things to say that they are mistaken on. But the only way you raise what you're going to say is to say, opposing counsel mentions X. Whether they mention a case, opposing counsel mentions bumper. However, in bumper, and now I just give my side of it, I don't re-hoe the ground that they've hoed, to use a metaphor. You leave that to them on their time to re-argue their own point. So this helps you both with questioning where the judge has asked a question, and maybe the judge says, well, opposing counsel said this, this, and this, and that's a good argument. What do you have to say to that? And you just say, well, Your Honor, on those facts or the case that you've mentioned, here's what was happening in that case. You give the facts, you give the rule, and you conclude your way. Likewise, during rebuttal, you've been listening, if you're defense counsel, to the whole 4-minute argument that opposing counsel was doing, and you've circled or noted 3 or 4 things that you're going to talk about. So you stand up and say, Your Honor, opposing counsel mentions this case, but in that case, fact and rule, and in this situation with our facts, you should go our way. Opposing counsel mentions this other fact, this other rule, but the applicable case is, that's the test, here are the facts. And so it makes your 2-minute rebuttal really powerful to just take the legs out from each of their arguments that you picked. The prosecution's rebuttal should only be a rebuttal of the defense's rebuttal. So the two sides get a little bit of an easier situation and a harder situation in this way, in that the defense gets to rebut an entire 4-minute plus argument with all of the questioning the judge does. So they have a lot more fuel for their 2 minutes. And then the prosecution has to only rebut the short 2-minute rebuttal, but the prosecution gets to speak last. And so that's kind of powerful as well. You can take comfort in knowing that if you can take those 1, 2, 3, or 5 things that opposing counsel said during their rebuttal and rebut them last, you get the last word, and it's very powerful for your score as well.